Basically, the offense that is alleged is one under section 307,
Attempt to murder.
attempt to murder.
Hmm.
Well, the how the courts have said, my lord, with regard to the attemptees, but for some intervening cause,
302 ಆಗ್ತಾ ಇದೆ.
had the act been completed, ಅದು 300
302.
ಅಲ್ಲ ಇಲ್ಲೂ ಅಷ್ಟೇ 307 ಆಗ್ಬೇಕಾದ್ರೆ ಬಟ್ ಫಾರ್ ಸಮ್ ಇಂಟರ್ವ್ಯೂನಿಂಗ್ ಕಾಸ್ ಹ್ಯಾಡ್ ದ ಆಕ್ಟ್ ಬಿನ್ ಕಂಪ್ಲೀಟೆಡ್. ಇಲ್ಲಿ ಇಂಟರ್ವ್ಯೂನಿಂಗ್ ಕಾಸು ಇಲ್ಲ, ಆಕ್ಟ್ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ. ಐ ಆಮ್ ಶೂರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ವುಡ್ ಸರ್ಟನ್ಲಿ ಅಗ್ರಿ ವಿತ್ ಮೀ. ಅಟೆಂಪ್ಟ್ ಇಸ್ ಟೋಟಲಿ ಡಿಫರೆಂಟ್ ಫ್ರಮ್ ಪ್ರಿಪರೇಷನ್. Preparation does not constitute an act of attempt. Illi. What is 307 according to them? Attempt to commit murder. How a basic minimum allegation for the court to have noticed the commission of a cognizable offense for the purpose of making an order of reference under section 156(3). No, exchange of messages. Kindly proceed with an assumption for the sake of argument, do not considering for a moment at this point of time that there are certain exchange of messages. Subsequent to the exchange of messages, there must be some act.
So it remained at messages only.
Ashte. Malad, I don't know how your lordship would recall to your lordship's memory under the provisions of the Essential Commodities Act under section 3 and 7.
7.
The state government would issue certain notifications
Notification under 7.
prohibiting interstate or interdistrict movement of
Prohibiting
goods
many
and all
things
that.
under 7,
Many, yes.
which becomes an offense under section 3.
Well, supposing I load the food grain into the lorry, it does not constitute an offense. It is only a preparation. In the last minute, my lord, I may realize, look here, what I am doing is incorrect. I will unload it. Then it will not constitute an offense at all. It is not an attempt. It is only a preparation. Now, attempt for what? Black magic is for what? To see that she is subjected to some kind of torture or harassment.
That is why, if I may say, 399 and 402 are differently worded.
ಅಲ್ವೇ
Preparation and attempt.
ಅಲ್ವೇ ಇನ್ನೊಂದ್ಸರಿ ನೋಡೋಣ ಇದರಲ್ಲಿ. My learned friend my lord invited my lord's kind attention to schedule class 3 ಅಲ್ವಾ? Schedule 3 ನೋಡೋಣ ಒಂದ್ಸರಿ.
Whoever attempts.
ಅಲ್ಲ no my lord, no
Schedule of the act.
Schedule.
no
Constitutes office.
no ಇದರಲ್ಲಿ ಗೋಸ್ಟ್
Under the pretext.
ದೇವ I don't know. My lord, probably in Gudiyaman my learned friend might have invited my lord's
Under
attention. Under the pretext of
expelling the ghost, assaulting by tying the person.
assaulting by tying the
And
person
Mata
with a rope or chain, beating by stick or whip to make the person drink footwear, soaked water, giving chili smoke, hanging a person to roof, fixing the roof.
Under Milord, under provision
Or
2.
by hair or pluck his hair, causing, what is all this?
Different Milord, because what happens, Milord, schedule has Milord item number 1 to 16.
ಇಲ್ಲ, ಮುಂದೆ ಓದಕ್ಕೆ ಆಗಲ್ಲ.
ಮುಂದಕ್ಕೆ ಓದಕ್ಕೆ ಆಗಲ್ಲ.
ಅಲ್ಲ, ಓದೋಕೆ ಇಲ್ಲ.
ಇಲ್ಲ, ಯಾವ್ದು ಆಗಲ್ಲ. If at all, my lord, at the worst, if we take the entire, my lord, allegation to its face value as true, it should come within the parameters of 1, 2 and 3.
Please.
Beyond it ಬರೋದಿಲ್ಲ. I'm sure my learned friend would certainly fairly
ಆಮೇಲೆ
concede.
ಬೇರೆನೇ ಇದೆ.
ಬರೋದಿಲ್ಲ, ಯಾವ್ದು ಬರೋದಿಲ್ಲ.
Practice
ಒಂದ್ ನೋಡೋಣ performing completion. Inhuman evil act and black magic in search of precious things, bounty and hidden treasure, or for similar reasons in the name of such as Banamati, Mata Mantra, assaulting any person, parading naked, or put a ban on his daily activities, or instigate, advise, or encourage committing of such inhuman acts. Ilbarala. Now, my lord, kindly go to 2. To create an impression by declaring that a power inapprehensible by senses has influenced one's body, or that a person has possessed such power, thereby create fear in the minds of others, or to threaten others of evil consequences for not following the advice of such person, or deceive, defraud and deter him. ಎಲ್ಲಿಗೆ ಬರ್ತಿದ್ದು? ಏನ್ ಮಾಡಿದೆ ಅಂತ 1, 2, 3 ಬರೋದಿಲ್ಲ, ಬಾಕಿದ್ರಷ್ಟು ಇಲ್ವೇ ಇಲ್ಲ. ಆಮೇಲೆ
ಬಾಕಿದವರು
ಬರೋದಿಲ್ಲ. ಇದು ಕಂಪ್ಲೀಟ್ ಆಗಿದ್ದಿದ್ರೆ, ಇದು ಯಾವ್ದಾದ್ರು 1, 2, 3 ಕಂಪ್ಲೀಟ್ ಆಗಿದ್ದಿದ್ರೆ ಆವಾಗ 307 ಆಗ್ತಾ ಇತ್ತೋ ಏನೋ, ಅದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಇಲ್ಲಿ 307 ಏನು? Well, now kindly see 380. Yes, alleged 380. Theft of jewelry. When? About 4 years ago. Not today. About 4 years ago, I stole the jewelry.
mother-in-law's jewelry.
ಕಂಪ್ಲೇಂಟ್ ನನ್ನ ಮೇಲೂ ಇಲ್ಲವೂ ಇಲ್ಲ, ಸರ್ವೆಂಟ್ ಮೇಲೆ ಕಂಪ್ಲೇಂಟು. ಈ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಎಲ್ಲ ಆಯ್ತಲ್ಲ, 3 ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಯ್ತು. ಫಸ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ವಾಸ್ JNWC, ಕಸ್ಟಡಿ ಆಫ್ ದ ಚಿಲ್ಡ್ರನ್, ಅದು ತಗೊಂಡ್ವಿ ನಾವು, ನಮಗೆ ಕೊಟ್ಟರು ಕೋರ್ಟ್ನವರು. Second proceedings was filing a complaint against him for an offense under the 490 and 34 of the Dowry Prohibition Act. Third proceedings ಏನಾಯ್ತು ಅಂತಂದ್ರೆ, I would file a petition against him seeking for a decree of divorce on the ground certain allegations which I have made. ಆಮೇಲೆ ಈ ಕಂಪ್ಲೇಂಟ್ ಅವ್ರು ಸ್ಟೇ ತಗೋಬೇಕಾದ್ರೆ some inaccurate submission has been made stating that he has filed a complaint against me. Therefore, I have filed a complaint against. No, that is incorrect. I can give your lordship the dates. Have a look at the dates,
No,
madam.
first petition for divorce is by you.
My complaint was of mine, petition was mine, everything was mine. ಅವ್ರದ್ದು after thought. ಇದೆಲ್ಲ ಆದ್ಮೇಲೆ he goes and files a private complaint. In fact, my lord, what the Supreme Court has said is, we have a common notion that under section 468 of the CRPC, my lord, the prohibition is imposed only upon the court. No court shall take cognizance of an offense excepting upon a complaint filed within a period of so and so. ಇಲ್ಲಿ theft ಏನು ಅಂತಂದ್ರೆ, the maximum punishment that is permitted under the law is 3 years. ಇವ್ರದ್ದು ಅಫೆನ್ಸ್ ಯಾವಾಗ ಆಗಿದೆ ಅಂತಂದ್ರೆ 2020 ಜನವರಿ,
Complaint,
ಫೆಬ್ರವರಿ 2023, ನಮ್ದೆಲ್ಲ ಆದ್ಮೇಲೆ.
1 month after the limitation.
ಅಲ್ಲಿಗೆ they can't contend that it is a case that is a prohibition imposed upon the court from taking cognizance.
Mhm.
Even a prohibition is imposed upon the policeman from taking the complaint is a law laid down by the Supreme Court.
No, that should not be mistaken. Cognizance can be taken after 10 years.
ಮಾಡ್ಬೋದು.
It is the act of the
Complaint-
complainant to
complaint-
file a complaint within
ಇಲ್ಲಿ
limitation.
What is
That
Supreme,
is not the
ಅಲ್ವೇ?
law is that cognizance ತಗೊಳಕಲ್ಲ.
ಅಲ್ವೇ?
Complaint
Yes.
ಮಾಡಕ್ಕೆ 3
Complaint
years ಒಳಗೆ
filed
ಮಾಡಿರ್ಬೇಕು.
within a period. But what the Supreme Court has said is, even when you go before the police, you should be well within time.
Yes.
The period that is prescribed is what the Supreme Court has
The-
said.
ಈಗ complaint is entertained. The court at its own ease takes cognizance after 7 years. That would not absolve the
ಅಲ್ವೇ?
accused.
ಅಲ್ವೇ?
It is
The
only
po-
the
The policeman
victim.
ought not to have registered the crime at all. Well, that
That
is
is
what the
clear.
Supreme Court has said.
ತಾರಾ ಮ್ಯಾಥ್ಯೂ ಅಲ್ಲಿ ಹೇಳಿರೋದೇ ಅದು.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಭರತ್ ದಾಮೋದರ್ ಕಾಳೆ ಕೇಸ್ನಲ್ಲಿ this is what the Supreme Court would say in paragraph 10.
No, the constitution bench in Sarah Matthew has clarified this saying that it is not, limitation does not run on the date on which the court takes cognizance, but
The date
on
of
the
filing
date
of the
on which the
complaint.
complainant registers the
ಅಲ್ವೇ?
complaint.
ಅಲ್ವೇ?
Cognizance ಗೂ 468 ಗೂ ಸಂಬಂಧನೇ ಇಲ್ಲ.
Otherwise, my lord, everybody would contend for no fault or sin on my part on account of some laches negligence on the part of the court. Why should I be
That is
thrown?
true. No, that
thrown
is why
out?
Supreme Court has clarified. Cognizance has nothing to do with limitation.